Just a real brief agenda you probably saw in your materials. I'm going to talk very briefly on how state tax regulations impact the seller's journey and just kind of give you a big 10,000-foot view of what's going on in the state regulation land. And then Robert is going to talk about the pitfalls of South Dakota versus Wayfair in broad terms. And then Shelley's going to get into the business side of things on M&A deals and divestitures and all the rest of that. And so we'll go from there. Let's start with the state regulatory environment. Now, as I described, I don't think any of us, and all of us have been practicing for a long time and seen a lot of tax changes. I don't think any of us were prepared or could imagine the result of South Dakota versus Wayfair. And the flood of state laws that have come out of this is incredible. I'm reminded of the movie Airplane. If you remember, when the plane is landing, the families are waiting at one gate, and then Flight 178, now at gate 17, now at gate 18, now at gate 19, and it keeps moving down. And that's exactly how these regulations have come down the line, these new state laws. I mean, legislatures are pouncing on this. Most state legislatures that have been already enacted a sales tax have enacted post-WAYFAIR legislation. And I think there's only two, like Missouri, and there's another state that haven't. Am I right?
Technically three, but we'll get into that. There's
okay.
Missouri, Florida, and Kansas.
Have not yet. I know there are bills pending in Missouri. I'm not sure about the other two states.
Mm-hmm.
And that doesn't mean that they're not still trying to collect sales tax.
Right, right. A lot of them have tried to piggyback on that. And so one of the things that we've seen, of course, is this tremendous onslaught of state law regulation that have come out of it, that a lot of states are mirroring the law that was upheld in the Supreme Court decision of South Dakota versus Wayfair. And I'll give you a little bit of the Reader's Digest condensed version, and Robert's going to talk a little bit more than I am. But basically, the Supreme Court decision, South Dakota versus Wayfair, overturned years and years of constitutional authority that either through the due process or the Commerce Clause, a state could not impose a sales tax obligation on an out-of-state seller unless they had some kind of physical presence in that state. And the South Dakota law in question had economic nexus. So if you had $100,000 of sales or 200 or more transactions, then South Dakota imposed a requirement to collect the sales tax on retail sales coming into the state. And of course, we all know through the web and what have you, most sales or many sales go through the web. And so that had a tremendous impact on the e-commerce business and on the sellers. So when the Supreme Court did that, many legislatures said, well, what the heck, we'll adopt those same kind of law that just passed muster in South Dakota, and they enacted very similar legislation. Some state, I think it was Maryland, am I correct? That the Maryland Department of Revenue, when it first came out, they weren't going to wait for the legislature to pass the legislation. They said, well, we're going to go ahead and impose a tax ourselves on out-of-state sellers. It was Maryland, wasn't it?
Well, Rhode Island, I believe, was the very first one, and they put the statute into place back in 2017.
Yeah.
So I don't know if that's the one you're referring to.
I'm thinking administratively, Maryland decided, the Maryland Department of Revenue, whatever they call themselves, decided, hey, this is what we're going to do. So it was a little unnerving that they decided to take it upon themselves. But I think since then, Maryland's probably passed legislation anyway.
But then again, California and Florida didn't have any legislation originally, and they were going after it based on the fact that Amazon had warehouses and various sellers had product in warehouses in California, in Florida, And those states were going after it based on pure physical nexus. So you didn't even know your product was in an Amazon warehouse in California or Florida, and those two states have now taken the position that they can go back to 2015 or earlier if you've had product there. So they don't care that they don't have legislation, although California, of course, now has legislation.
And Shelley, are they asking them to prove that? Prove that they didn't have inventory there?
Not really. They subpoenaed all the information out of Amazon, so it's not really a matter of proof because Amazon had to comply with the subpoena, so they know. It's really, and California's being very aggressive about it, and we're going to talk a little bit about California, so we'll come back to that one.
So California, it's my understanding, you'll correct me if I'm wrong, Robert, they adopted a Wayfair legislation, South Dakota legislation, $100,000 or 200 transactions. And they probably found it was just too cumbersome to administer because California is a lot bigger state, obviously, a lot more people than South Dakota. So they changed the legislation to $500,000 a year in sales. Nonetheless, as Shelley is pointing out, they're being very aggressive even pre-Wayfair. They announced after the Wayfair decision, well, that's okay, we have this new legislation and all that, but we're going to go back on the basis of inventory for the Amazon sellers because Amazon has big facilities out in California, and if you store your inventory out there, you may not even know you have inventory out in California. That's close enough for physical nexus under the prior constitutional standard, and so we're going after that as well.
Well, and Amazon had challenges to let their customers know that they had inventory in California or wherever, because you could run a report, and I think you had to go through a third party to get that report. You had to run a report to find out where is my inventory. And they could tell you where your inventory was as of the date you requested it, but your inventory moves around all the time. You don't know where it was yesterday, you don't know where it's going to be tomorrow.
Yeah, that's exactly right, because your inventory is always in transit, and Amazon has the right, as does Wayfair. It's not, so you keep talking about Amazon and the Amazon rules. This applies to all marketplace sellers. So Walmart's a little different. You could be in the Walmart marketplace, and they move all of the product around as well, but they work a little differently. But Jet, which is owned by Walmart, works this way. Alibaba is eventually going to get into the United States, and it works this way. Wayfair has a similar structure. So all of these companies are moving your inventory around based on their predictive needs, not necessarily based on where you asked to have your inventory. So you don't necessarily know where it is. Just a side note on California, so one of the wonderful things California did for us is they actually came forward and made an announcement. They're only going to go back to 2015. Because originally they were going back to the very first Amazon warehouse, which I believe was 2013 in California. And so they were, as a courtesy, they're only going back
so
to 2015.
Yeah.
And I don't know if you, you may not read this stuff the way I do, but there's a guy in Philadelphia who sells clothing and other sundry accessories, women's accessories, and he received, this was in the paper about 2 weeks ago, he received a notice from California demanding $1.6 million for back sales tax due. That was their estimate of what he owed. And his response was almost basically impossible. One, he hasn't been in business that long, and he certainly didn't sell enough in California to owe $1.6 million. And so he says he's going to go through and fight this, and I'm just getting this out of a newspaper article. But even if he's right, he now has an added cost of proving it. Mm-hmm. And so you can imagine what the disruption is to an online seller. In my case, a lot of my clients are based overseas. They looked at it and said, we don't have to do this. But how are they going to get us? But there's a reality that California's staffed up. They're prepared to go after people, and their numbers are all based on what they got out of these marketplace seller and facilitators, and then they're extrapolating.
Yeah.
they weren't quite staffed up for $100,000.
Right.
And then they, like you said, they increased it in April of last year, or I guess it was about late February, early March, where they increased their threshold to $500,000. Well, the threshold was $100,000 from January 1st until end of February, early March, and then they bumped it up. So we actually had clients, I don't know about you guys, but we had clients that registered with California because they met the 100,000 but may not meet the 500,000. So
Right.
now what do? They deregister? Is it worth it to deregister? Are
They're
you
gonna come after
going
you
to
and
eventually
wanna
get
know.
to that 500 shortly? They had some things to think about. They
Well,
ended
we're
up
gonna-
staying registered, but
Yeah.
Well, we're going to talk about marketplace facilitator a little bit later, but keep in mind, if you have a Shopify account or you have a website on which you sell, or you perhaps have a phone line, back in the day when I was at Sherwin-Williams and we created the first 1-800 wallpaper line, and that was in the 90s, and you could call and order your wallpaper. No one knew it was Sherwin-Williams you were calling, but nevertheless, we had all those kinds of facilitations in place. And if you're selling through Amazon and you trigger because of Amazon, as far as those other sales go, they're triggered. So if you think you're okay, just register. And California's issued regulations on this, by the way, so there's a book. It's online. And if you think you have triggered under the Amazon rules, even though Amazon may be collecting for you, you've triggered even if you just sell one more product and you ship it to California, you need sales tax on that one product. So this is,
It's very administratively, if you can't tell, this is
It's a huge burden.
huge challenge, even if you want to be compliant.
for us old lawyers who, remember the world of interstate commerce, and the whole goal was not to burden interstate commerce. I don't know what to call this.
That was the whole point of the Dormant Commerce Clause. Now, of course, if you read the Supreme Court decision, Congress is free to change that decision and set uniform rules, but I'm not sure they can agree that, today is Friday, much less what we should do about something like this. And just real briefly, Ohio kind of did the reverse. They had a $500,000 cap, and then they changed it back to the South Dakota 100,000, 200 cap. Missouri is stuck in limbo, as I said. There was legislation that was proposed along the 100,000, 200 sales line, but it really hasn't gone anywhere. I suspect Missouri will catch up with that because there's just too much money for these states involved.
And keep in mind, if you're headquartered or have offices here in Missouri or a warehouse here in Missouri, even if they don't have an online requirement, you still have physical nexus. So if you're not registered in Missouri and you're in this room, you need to call one of these guys.
And Missouri's challenge with getting the statute in place is the old court case that says that use tax cannot be higher than the sales tax. So right now in Missouri, we have jurisdictions that have a use tax rate of 4.225. They have, and so if Missouri, they also have jurisdictions that we have, St. Louis is like 9 or 10.1%, something like that. So that's a huge difference. So what tax rate is Missouri going to put in place? Is it just going to be the use tax rate for these remote sellers? That's what they've been challenged with. They wanted to make it easier on taxpayers, so they wanted to make it a consistent rate. So one of our senators put out a bill that said, okay, we're just going to make it a 6 1/4 rate. So it's easier on the remote sellers to collect 6 1/4. What he didn't, well, he addressed it, but the way he handled the higher use tax rate, because you're going to have jurisdictions with the sales tax rate that's 4.225. Well, now you have a 6.25 use tax rate, which is higher, which is unconstitutional in Missouri. So the way he tried to handle that was, well, if you're in that 4.225 jurisdiction or something lower than 6 1/4, then you can file a refund for the difference. So basically, he took the burden off the remote sellers and put the burden on the Missouri purchaser to get their refund back. Well,
Think
that's
about
ridiculous.
That as a practical
That's-
matter, yeah.
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 That's impractical. It's ridiculous to expect a purchaser to even know that they can do that, much less go through the process of filing the refund.
Right.
That bill did not get, it was not selected as the bill to push forward, but it was just, those were the kinds of things they were thinking about, and that's why it's taken so long. There is one in process, it's just not, it's not passed yet.
But I would expect that they're going to figure something out, because even if you're taxing at the lowest rate at that 4.2, that's something. It's better than nothing. And I think that maybe they work out the state constitutional challenges. They're going to work those things out eventually. But right now, I suspect that the goal will be that, you know, half a loaf is better than none. Let's get something in the pipeline, because all these other states are doing it. Illinois adopted South Dakota type legislation. $100,000 of sales or 200 transactions. And what's amazing about that number, 200 transactions, and didn't South Dakota get rid of that limitation? I think South Dakota got rid of the 200 transactions because it's just too impractical. Because if all you're selling are items that are worth $25 or something like that, it's just not practical to sell into the state. In terms of cost.
I know they were considering it. A number of states have gotten rid of it. They've just decided if you think about it, a lot of these remote sellers, they may sell something for $10. You know, at 200 transactions,
right,
that's $2,000.
Right.
So, you know, it's a big difference between that and 100,000. So a lot of them are getting rid of the transactional piece of it, but it's still out there.
It's still out there. So what are the practical effects? And of course, Shelley can wax and talk all day about this stuff, but of course you have enormous compliance costs. There's software out there, as we discussed last time, and it's got to be continually updated, and you have to pay a lot of money for it. So if you're a remote seller, you got to think about your transaction. If I'm only doing 200 transactions, I'm only doing $100,000 of business, how am I going to comply with that? And my compliance cost is going to be more than what I'm taking in by the time I get to Sunday and get it done.
And we're going to talk later about what that means if you ever want to sell your business and how that might play into your future sale.
Now, there's streamlined sales taxes. Is it 30 states now, Robert? How many states?
Yeah, that's about right.
About 30 states where you can register on one place, and you'll register for all those states. And the consideration, I suppose, is if I do that, then what if I'm paying or collecting on taxes on states that I hardly ever sell to, that I would not meet the minimum threshold? So you got to so there's considerations of that. There's audit considerations, because as Shelley was mentioning, these Department of Revenue, they'll go directly to the Walmart or to the Amazon or whatever to collect their data. So they're going to know about it, and they're going to go aggressively against these companies. They have been.
And if we back up just a second on the streamlined sales tax, yes, you can register through streamlined sales tax, and we've done that.
Yeah.
One thing to consider is once you do that, you're going to get a bunch of notices from each of those states. And those notices are going to be, well, you know, we understood you registered through Streamline. We also need this information, that information, this information, that information. And you have to, so it's almost like filing an application. It is shorter and somewhat easier to do, but just know that the states are going to be contacting you with the additional information that they need. And Streamline warns you about that whenever you're going through Streamline. So unless you want to deal with each of those, it would be a good idea to have somebody to help handle all of those. And be your go-to person.
Even in the states that aren't streamlined, if they're getting information off of their subpoenas, those letters are still coming to you, even in the independent states, with a whole questionnaire about what your sales were into the state.
Mm-hmm.
So some of these things will be ripe for litigation. We're going to see in the future, like I said, income taxation, because South Dakota versus Wayfair was solely on sales and use taxes. Is there an argument, even outside of the 86-272, for constitutional challenges to an income tax? We'll see. Physical nexus is mentioned. That's still with us. So as we were saying, if you have, Shelley was saying, you have presence in a state, doesn't matter whether you are under the $100,000 threshold or not. If you physically have a small mom and pop shop here in St. Louis or over in Illinois, yeah, you still got to collect the sales tax. That has not changed at all. If you have any kind of physical presence, the states will ding you, and as we were talking about with California, that might mean even transitory inventory being stored in an Amazon warehouse for a few days, and they'll still view that as being good enough, even though you may not meet the $500,000 remote seller threshold.
And the physical nexus, if you have had physical nexus going back, once you go through this process and determine, well, we've always been there, we've been there for the last 5, 10 years, then make sure you make sure you think about a voluntary disclosure opportunity there, to cut out the penalties in some states with the interest, and that can reduce your liability. And we've had well, there's a lot of companies out there that are capitalizing at this point in time because of Wayfair and because the states are so busy that we're going to register and go forward on this, even though maybe we have had Nexus in the past, but we're going to take the chance that they won't, that they're not going to come after us. We're just going to register going forward. And then
Right.
Once you get past the statute of limitations, it's less likely that they're going to go back. They still have that ability because you were never registered during that time, but it's less likely.
Yeah, it's kind of interesting because, in certainly federal law, and I think state as well, if you fail to register when they think you should have been, or you fail to file a return, I don't know if the statute even runs.
It doesn't. They can go back as far as they want.
So it's kind of crazy, but most of my clients are looking at this prospectively and are kind of biting the bullet on the backlog, and hoping that they can solve the problem going forward and that'll satisfy most states. And I think other than California and a few states, it seems to at least not have caused the states to look backward. I think they're happy to be getting something going forward, but there's no guarantee that once they get through this backlog that they won't go and look retrospectively.
And Robert knows this. Once a state gets you in their viewfinder, if they don't like you for some reason, or like the IRS, I mean, they don't like you for some reason, then they will go back as far as they can. So you never know when you win that audit lottery and or I guess lose the audit lottery is probably better. They're going to come after you big time for that, and they just, because they don't like the cut of your jib or whatever it is. So one of the things that we might want to take a look at is what kind of entity. Do we want to put up some firewalls if we have a conglomeration of businesses? Do we want to separate those businesses out? Because if the state comes back with a whopping $1.6 million bill like that fellow in Philadelphia, and there's no way he can afford that, is there a way to protect the assets of other businesses from that kind of liability by looking at separate corporations, separate businesses, et cetera, et cetera? And maybe brother-sister corporations with a holding company, however you want to do that, but that's one consideration. What's the worst they can do to me if I have separation, and look at it, what kind of firewalls do I need to put up going forward?
Now, keep in mind there are fraudulent conveyance laws.
Right.
And as much as it sounds like a great plan, if you simply stop doing business in Entity 1, move all of your sales to Entity 2, and there isn't a transfer of assets for fair value, there's a high probability they're coming after entity two, because that was a fraudulent conveyance. So the question becomes, what if it's just a brand new business? You're not actually transferring assets, you're not transferring your Amazon account, you're not transferring your, whatever Seller Central, other seller marketplace accounts. You're just literally starting a new business. You might have a better argument, and it's only the original business that's tainted. But if you're actually moving your sales, and
Right.
they're going to follow, and we're going to talk about bulk sales in a little bit, but there's a high probability the states will eventually follow it.
And then you also, and keep in mind that if you're considering that, changing the entity or whatever, keep in mind there are affiliate nexus laws, so they have to be completely different. So if you have an entity here named XYZ, and then you have an entity over here named XYZ sub, whatever, and it's a similar name, they're selling a similar product, or at least it's very related, then your affiliate nexus laws are going to kick in, and they can go after both companies. And some have actually pointed out that they're using an aggregate sale
Right.
as a way to meet that threshold. So then you have, they would take the aggregate sales between both companies to determine if you're hitting that nexus. So if both companies are under $100,000, but both of them together are over 100, then you've met the threshold.
But certainly in a case where you have totally separate lines of business, and this is just law school 101, everybody kind of know, you got to separate out, keep east is east and west is west, don't mix the milk with the meat, right? So you want to keep those separate. So if you have a wholesale business over here that would never collect sales tax because it doesn't sell at a retail, and you have your retail business over here, absolutely you need to keep them separate, because you don't want the states start looking at, well, what are you really doing in that wholesale business, and then start to ding that for the liabilities of the retail business.
So kind of along that same line, and his next point is M&A, but these are kind of integrated topics.
Right.
So I have a client who has acquired a couple of UK companies, and they are UK based, but they were selling in the United States. And because of the way Amazon works in the UK, it's easier to buy what's the equivalent of the stock of the limited in the UK than it is to transfer and do an asset deal, because it's very hard to move assets, and with the VAT and the way it all works in the UK, it's hard to do it. So these are stock deals. The challenge is they were selling in the United States. They've never collected sales tax. So the seller in our world, we're going to talk a little bit about how we did these escrows and different things for this, but my buyer, my client, picks up the stock of a company that has never paid sales tax in the United States. The decision we made was to actually use this kind of entity structure. We formed a new entity that purchased the assets of the U.S. operations only, moved the U.S. Amazon account, and that is a fresh start. We know that the old company, the UK company, still has the backlog of the sales tax issue. But we did it quite intentionally, because now the seller has the liability for any sales tax he didn't pay while owning the UK company, but we have a hard line. Because the buyer has registered his new company for all the US sales, and immediately upon initiating that company is registered in all 50 states and is selling and is paying and collecting sales tax, that UK company we assume will eventually be tagged, and it will, I'm sure they're going to come after the whole structure, that little parent US company and this UK company. But it was a way for us to be able to identify what the seller owes, and we'll talk a little bit, because we actually have set up a holdback and a escrow structure to address that issue.
One thing that, along those lines, when I was a young lawyer, we had a major multi-million-dollar transaction going on, and for whatever reason, I was asked to sort of quarterback this thing. And of course, the buyer was a big conglomerate, and they did a lot of due diligence on the company. And this particular company was a manufacturing company, matter of fact, but it was so well run. Dot the I's and cross the T's on everything. Insurance, corporate minutes, employee handbook. I mean, you name every single thing that they could comply, they did. And so when the buyer looked at this, they said, well, what the heck, we'll buy the stock of the company, which is a little bit unusual because you don't necessarily want to pick up unknown liabilities when you buy the, the equity of the company. So the point of my statement here is that it's hard to get clients to understand the importance of getting in the compliance thing, but when they go to sell the business down the road, it sure is nice not to have problems like your UK company that you have to structure holdbacks and go through all these hoops if you have a very cleanly run company. So you may have clients out there and say, oh, they'll never catch me, or oh, I don't make that enough sale, or I don't sell through Amazon, and blah, 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 blah. That's not the point. The point is that someday some buyer is going to be looking at that business, and they're going to be wondering, why haven't you complied with South Dakota? And we're going to not do the deal because you have not been compliant, even though you've never been caught even, let's say, or ever had a problem. So it's just a little piece of advice, if we can give our clients, how important it is to keep up as best they can with compliance. No company's perfect, but as best they can.
And Shelley, I don't want to jump the gun, but you have a number of clients that have dealt with that specific issue, right? Where the buyer comes in and goes, whoa, you have too many sales tax liabilities, and they ran.
Right.
Yeah, and that's, we're going to get to some slides on that, but I represent both buyers and sellers. So it's not unusual for us to deal in the last 18 months with this issue. And it's hard. We're going to talk about bulk sales. There's a whole bunch of things that in the first, I've been doing the e-commerce type work probably for about 8 years now, where it's been a major part of my practice. This is like a new world. Because a lot of what we were doing before just doesn't apply anymore. And I think I'm going to wait till we get to the M&A slides about some of that, because I think I have specific examples there.
So last year, this is kind of what the economic nexus by state chart looked like. Kind of ugly with all the different symbols, but the blue states had some sort of law regarding economic nexus. And some of those states actually were looking at it retroactively. We had mentioned Rhode Island initially. They had a law back in 2017 where they were one of the front runners. Alabama was the front runner, I believe. But Rhode Island was also one of the front runners to put these statutes in place, even though they knew they were unconstitutional. On this chart, I'm not sure why Rhode Island's not blue, but
Too small to see anyway.
Maybe, yeah. This is what it looks like today. So pretty much everybody, and I'm going to talk about Kansas and Alaska, because those are exceptions to the rule, technically. Even with Kansas being blue, it's blue because the Department of Revenue put out guidance saying, hey, if you're selling into our state, then you have nexus with our state and should be collecting our tax. They didn't have a threshold. They just basically followed the South Dakota Wayfair decision with no thresholds at all. What was interesting is the state attorney general for Kansas came out and said, no, the Department of Revenue can't do that. What they've just done has no legal force in effect. So though Kansas, and that was their own attorney general that did that. So by doing what the Department of Revenue in Kansas did, they've basically squared off with their own attorney general. The reason they did that is they couldn't get the law passed. So there's been numerous bills in Kansas that have made it all the way to the governor's office, and she has vetoed each one of them. She has a good reason for vetoing each one of them. It has nothing to do with economic nexus. She's vetoing them because of all the additional pork and whatever you call it, pork barreling that the legislators do when they see a bill that is a slam dunk to pass. They'll throw all these tailors on that have nothing to do with the bill at all. They just throw them on there to try to get those passed, and they can be completely different than what the bill is originally for. So whenever that got to her office, she vetoed it every time. So they couldn't get it passed. She would say, she said, I don't like this, I don't like this, I don't like that. So I'm vetoing it. And then the Department of Revenue put in their, not really a rule, it's more of a guidance. And then they got their hands slapped by their own Attorney General. So though Kansas is blue, it's technically unconstitutional, so they really don't have anything. Alaska is interesting. Alaska, most of us see Alaska as a state that has no sales tax, but they do. They have no state sales tax. The local jurisdictions in Alaska, a lot of them will have a sales tax. The reason you don't hear much about it is the two biggest jurisdictions in Alaska, Fairbanks and Anchorage, don't have a local sales tax. But all of these locations that you're probably never going to go to, you may never sell to, they'll have a tax rate, and it could be up to 9%. So Nome, the city of Nome, put an economic nexus ordinance through. So they're the only ones. So Alaska is technically gray here, but just know that the city of Nome recently passed their economic nexus rule. And Florida is the other one. Missouri, Florida, and Kansas. The other gray states don't have a tax, a sales tax. Okay, just some things to point out on this chart. This is the state legislation for economic nexus. One thing to point out is look at Arizona. They have tiered their statute. So it's $200,000 threshold for this year. Next year it goes to $150,000, and the year after that $100,000. There is no transaction threshold, just a sale threshold. And you'll notice on the threshold criteria here, most of them are gross, some of them are retail. The retail ones are more reasonable in my opinion. Those that are gross are somewhat unfair because you could technically, if you are a wholesaler and you are hitting the thresholds in all of your states, you technically have a filing responsibility, even though you have no tax liability.
That's your reseller filing, is that what you're talking about?
Like a wholesaler or
A wholesaler
reseller,
or
someone
reseller
who's selling
certificate.
Sell products to somebody else. They wouldn't collect retail sale because it's not a sale at retail by
Right.
any state definition. But they're only looking at the gross sales to the state, not whether it's retail or not. Like DC is only on retail sales. So if you don't make retail sales to DC residents, you're fine.
Mm-hmm. So if you're always selling to resellers, then you could have a filing liability but no tax liability.
Right.
California, California, as we stated, increased theirs to $500,000 when it was $100,000, but it is sales of tangible personal property. My misspelling there. Connecticut is another one that reduced theirs. They went from $250,000 down to $100,000, but they left the and 200 transactions. So if you have $100,000 on 199 transactions, you technically don't have a filing responsibility yet. You have to hit both of them. The state of Kansas, we talked about. They're currently at any, which is, like we know, is unconstitutional, even under the South Dakota Wayfair case, still unconstitutional. Massachusetts was 500,000 and 100 transactions, and they've reduced theirs to just $100,000 and took away the transactional portion of it. Missouri, as we stated, currently proposed. New York was another one that they had theirs at $300,000 and 100 transactions, and they've increased it to 500 because the 300 was just too burdensome for them. They weren't concerned about it. The taxpayers, it was too burdensome for them to process those returns. Because to be quite honest, the states don't want to process zero returns either, because it's just a cost to them. But under some of these statutes, they have forced us to have to file a zero return because we're hitting the threshold.
So, Robert, are you seeing anything on casual sales? You know, my example is sometimes you sell, I don't know, a piece of art, a very large jewelry transaction, but there's only one transaction, but it's over 100,000.
I think you have, if it's an occasional sale, if you don't typically sell art, then you're going to be protected under the occasional sale exemption in that state if they have one. You have to be careful in looking at those because sometimes they have an occasional sale exemption, but it's impossible to meet. California is a great example of that. Yes, they have an occasional sale exemption, but no one ever meets it. Missouri has an occasional sale exemption, but it doesn't apply to businesses technically. They put that statute in place for, like, if you're doing a yard sale. It's those kinds of transactions that can qualify. But once you get up a certain amount, I think it's $3,000, I want to say, in Missouri. Once you hit the $3,000, then you technically should be collecting the tax, unless you're doing a yard sale kind of
right, so my favorite example is you have a person, in the old days, if you had a store that was in a single state and they shipped your product to another state, there was never sales tax. I mean, there was supposed to be use tax, but there was never sales tax on that. And it was very common. People would travel to a state and buy their major purchase and ship it home. Well, today, under these new rules, I think it's questionable as to whether you can really even do that. So, one shipment, if it's big enough, if it triggers, could cause a retailer to actually have been obligated to collect sales tax and register in the state into which it's shipping.
And I have a war story on that. This is going way back. This is before even Quill, I think, came into, maybe right after Quill in 1992. Shows you how far back I'm going. So this company made a one-time sale, to the state of Ohio, and I guess Ohio had audited the buyer's return, whatever, and they were coming after the client for $1,000 in sales taxes. So we wrote it back in the old day. It was either the Bellis-Hess case or the Quill, I forget which one was in effect then. And we said, well, you don't have any, because it's a one-time sale. It's all they did was one sale ever in the 50-year history of the company. Never sold anything to that state. They came back and wanted income tax returns in addition to the sales tax. So we ended up telling the client, if they reduce $1,000 to a judgment and they register it here in Missouri and write them a check, open up your checkbook, write them a check for $1,000. It wasn't worth arguing with them.
So with the states, like we said, there's only a few left. Notice that Washington, going to the next slide, Washington is $100,000 or $10,000 collector notice requirement. So if you're not hitting the $100,000, but you're at above the $10,000, they still have a collector notice requirement in their state. That comes from the Direct Marketing Association case a few years ago in Colorado. Colorado was trying to get the states to force, or was really trying to get a case to go to the Supreme Court, which it did, but in that case, the Supreme Court ruled that since it was no tax, since they weren't requiring a tax, they're just requiring a notice, which is basically what I call the tattletale law. So if you're selling to customers in Colorado back then at the end of the year, you had to provide a report to the state of Colorado saying, these are all the people I sold to, if I sold above a certain amount to them. So these are all of my customers in Colorado. So that gave the state an opportunity to go after those customers because they technically owe the use tax. And they had no avenue of reaching that transaction. So they put that law into place to try to force the Supreme Court to force the sellers to start collecting tax everywhere. It didn't work because the court said this is not a good case to overrule Quill. But Justice Kennedy...
Yeah, I was going to say, Justice Kennedy filed a concurring opinion saying it's now time we revisit Quill.
Yeah, but this wasn't the case to do it.
Right.
And that kind of started that's when South Dakota Wayfair, that's when South Dakota, that's when Alabama, and they started putting statutes in place to try to get them to the Supreme Court, which eventually worked. But you'll notice that most states have gotten rid of their collector notice requirement because when that case went through, they started putting those laws into place because at least they'll know who's not paying the tax. Well, states have started to get rid of those. Washington, I think, is the last one to hold on to it. So what can you do? As we've been talking about today so far, registration and collection is important if you're hitting those thresholds. But one thing to also consider is if you need to register with the Department of Revenue, you need to consider whether you need to also register with the Secretary of State. Because the Secretary of State, if you're actually doing business in the state, then the Secretary of State has filings that you have to do as well. So if you're selling into a state and shipping via common carrier, then typically you don't have to register with the Secretary of State. Any other connection will typically require registration because you're considered to be transacting business. Here are a few exceptions to that. I think you all have it. We don't necessarily have to go through them all in the interest of time. But this is the general rule. Some states are a little different, but generally they follow these definitions. So if you're not, if you're not transacting business in the state, if you're doing any of these things, you're not transacting business in the state. If you're doing more than these, then you have to register with the Secretary of State. And that's important to remember because sometimes those penalties are not very friendly. So we had one of our clients wanted to register in Illinois. Illinois was the example. And he realized that he had NEXUS technically before this year. He had a new company, but he had a salesman going into Illinois last year. So we checked with the Secretary of State because he was wanting to register going back, and he was willing to do the sales tax returns for a year if that was necessary. He just wanted to be in compliance. We talked to the state, and they said, well, the penalty for him not registering last year is anywhere from $15,000 to $30,000. And that was a bit more than he wanted. So just know that those penalties can be significant. Potential penalties if you choose not to register, and sometimes there are situations where materiality, it's just not material, or I'm going to just accept the risk. And we realize that those are situations that companies have to consider. We may advise you one way, but you may choose to just accept the risk. Those risks will typically involve interest, non-filer penalties, transacting business penalties, which those are the Secretary of State. Fraud penalties, especially if you're collecting. We've had clients that have been collecting and just didn't realize. I had one client that just didn't realize that they needed to pay that to the state. They figured eventually they needed to collect the tax, but wasn't sure what to do with it.
And keep in mind, in most states, and maybe all states, if you collect sales tax or payroll taxes and you don't pay it over, there's personal liability for owners, for officers, for directors. It's a little bit different than other kinds of taxes, because it will, these states will pierce the veil and come directly to you for failing to pay over.
So if you're going to collect the tax, make sure you register first.
And then turn it over.
Yes,
Yeah,
right.
oh yeah, absolutely.
Right.
You don't want a trust fund penalty. It's called a trust fund penalty. You don't want a trust fund penalty.
Yeah, the states are not very friendly there because like I said, they consider that fraud. So they tend to frown upon you collecting it without being registered. So things to think about: where do I have sales tax nexus, whether it's physical or economic? If it's physical, then you need to consider a voluntary disclosure. If it's economic, you may be able to avoid filing a voluntary disclosure, but just know that if you do have physical nexus going back, then the state can always go back and get that. The more you get past the 3-year, 4-year statute of limitations in that state, they're less likely, but they can always go back because it's always open. So obviously you have to think about what states do I need to register in, what's the materiality, what states can I assume the risk, do I have a tax calculation engine, am I capable even of collecting the tax, and do I have my tax processes documented. So one thing that, when the case came out, it was on an online retailer. So most people thought, well, this applies to online sales, not sales that I might make into the state where I ship my product out there, where the customer may call me and buy, and I ship it. Just know that this new court case is not only applicable to online retailers, it's applicable to all sellers. Will there be a grace period for getting registered? Yes, typically. Once you hit those thresholds, you have about 30 to 60 days to register with the state. Will this remaining states enact the thresholds? As we discussed earlier, yes, we expect them to do it within the next year. And when a company reaches the threshold, do they have nexus going forward or next year? Once you reach the threshold and you have to register, you generally have nexus going forward. If you're never hitting the threshold after that and you have no physical nexus in the state, it's usually a 2-year period before you can deregister. So you'd have to file 0 returns for a couple of years. And then if you're not hitting the threshold, then you can deregister. But generally, once you have nexus going forward. Will it be retroactive? Generally, no, but as Shelley said, if you have physical nexus there, that is retroactive, and they'll go back as far as they need to. California, and what did you say the other state was? Florida is doing that. Even though Florida has no economic nexus statute, they're going after the physical nexus. And do non-taxable transactions count toward the thresholds? Generally, yes, as we showed you in the chart. I think we've picked on the income tax nexus quite a bit, but you have some protection under Public Law 86272, but don't be surprised if a lot of states go after it like Hawaii and North Carolina have done. Because when one state is successful with that, then the other states tend to be copycats. And will they increase audits? Probably, because they're getting all this new revenue that they never got before, so that gives them more ability to hire more auditors, which leads to more audits, which leads to a better chance of you getting caught.
So I fondly refer to this law and what's been going on for the last 18 months since Wayfair as, we can write a script for a movie called Catch Me If You Can, because that's how most people have been handling this. They're saying, oh gosh, you know what, I'm not dealing with it, let's see if they catch me. But that's, yeah, I think the reality is it's going to change, because originally we thought the states wouldn't staff up, but the states see the economic opportunity and they're going at it. And I think that you'll start to see more states getting aggressive. And you know, in the movie title after Catch Me If You Can, you know, will include orange suits and stripes.
Yeah, and like, if you take that avenue of catch me if you can, then when you do get found, it's going to hurt.
Yeah.
So potential pitfalls, of course, penalties. We've touched on the amnesty, voluntary disclosure opportunities in the states. Amnesty is where the states have a certain period of time where you can register and they won't bother you going backward, or you can register and they'll take away the penalties, so it's not as painful for you. But generally you're not going to see, it's not going to be an amnesty period. You might find a state or two that's in an amnesty period, but they usually last just a few months. It's not an open amnesty generally. They'll institute one, say, for June through September. So if you file in that time period, then you can get the advantages of an amnesty. Otherwise, you're going to have the penalties. Income tax economic nexus is a major pitfall as we get further down the road. I think there's going to be a lot of court cases on that, so that'll be fun to watch for some of us.
Yeah.
Tax returns will become due based on the date you start doing business in the state. So practical things to consider. Norm, you want to start on this one?
Oh, sure. That's fine. Well, as we were talking about, you know, you want to get ahead of the curve. And a lot of the remote sellers and what have you, it's, as Shelley said, catch me if you can, and that's not a very healthy attitude to have on any compliance issue, whether it's IRS or state. And so you want to consider voluntary compliance with all of these rules as they come online. And as I said, if nothing else, it makes you a more attractive target for some takeover company if you're in the market to sell the company than it would have been otherwise. The streamlined sales tax agreement we covered, that can make things a little bit easier in terms of registration and getting forward, not that you won't get follow-up questions from the various states that belong to that. You want to go ahead and
this
switch?
KFC Corporation case, I don't want to get into it
Yeah.
too much detail. It was a 2010 case. It was in regards to, KFC had franchises in Iowa, but they had nothing else in Iowa. They had franchises in Iowa, and so they got the franchise fees, but they didn't own the property in Iowa. They didn't have locations in Iowa because it was the franchisor, or the franchisee that had them. And they would pay the royalties to KFC. Well, KFC got dinged by Iowa because they have their labels on the chicken. They have, they're using their name, they're using their brand in the state, and so the state of Iowa was able to go after them for income tax.
So again, being ahead of the curve is in the client's best interest. Whether they do it or not is another question. Sometimes, in addition to what they can do to go after Amazon and Walmart and all these marketplace sellers, they can send the questionnaire directly to the client. And these are not to be ignored. The client should not just ignore it or try and fill it out themselves. They really need professional help when completing those, because one little thing off and they will use it against your client. So it's very important that if you do get the NEXUS questionnaire that comes out that you comply with the requests in a reasonable manner. And my experience dealing with the IRS and various state departments of revenue is if you deal straight with them, then they'll deal straight with you for the most part. You always get somebody who's not too nice or whatever, but for the most part, if they see that you're trying to comply and you're trying to figure things out, then they'll be very helpful for you. If you get into a situation where you're being dodgy with them and not compliance or whatever, then that'll get their attention. It's waving the red flag in front of the bull. And so you'll have state collection, and once they get that, they can make an assessment against that. They can reduce that to judgment. So this fellow in Philadelphia has to worry that California is going to reduce that assessment of $1.6 million to a judgment, register it in Pennsylvania, and start collecting on assets. So that's a big time risk. If it comes down hard knuckle ball, and a lot of these states will do that. We never had a problem with the $1,000 guy. Somehow Ohio never got around to doing that. They tried to intimidate him into paying it, but they never got around to.
And just know, sorry.
No, go ahead.
And just know that there are still certain exemptions or loopholes that you can use. You do have the remaining constitutional defenses under complete auto.
Right.
We won't go into that. That can, that's best for an offside discussion. But just know that you still have those protections.
Right. Shelley?
Okay. I'll take the clicker. I'll just do this from here. So my slides are pretty content heavy, but they are fortunately the kind you can read because I want to leave time for questions. Couple of things that have happened since this whole Wayfair decision, and it's changed the way businesses are being sold. It's changed the way transactions happen. Okay, so I have given you some content-heavy things on your table. First of all, bulk sales. Any of you, buy or sell companies in the last 40 years, 50 years? Everybody waived the bulk sales laws, okay? It was pretty standard. The buyer and the seller said, we'll take that risk, we'll indemnify you. Not anymore. Because of Wayfair, especially in the e-commerce world, we are seeing buyers refuse to waive bulk sale. And I'll tell you what, when I represent a buyer, I'm not waiving bulk sales anymore. And when I represent a seller, I politely put in the waiver. And hopefully, buyer's attorney doesn't really understand this stuff. Sometimes I'm lucky, sometimes I'm not. Sometimes we get into big fights over the topic. So here are the problems. If you don't waive bulk sales and they say we want you to comply, in states in which you've never registered, you can't get a clearance certificate. Okay, in the old days it was easy. You had 1 store, 5 stores, 100 stores, all in one state. It was one state, you were registered. Well, now you're doing business in 50 states. You might be a business based in Hong Kong or the UK or here in Missouri. It doesn't matter, but I can't get you a clearance certificate in a state you're not registered in. There's just nothing I can do about it, so it makes for a messy deal. My most recent sale that we closed a couple weeks ago happened to be a New Jersey company, and he was registered in New Jersey. The buyer insisted on complying with the bulk sales laws. We said, fine, we complied. 10 days later, we got a notice from the state of New Jersey. Please withhold $448,500 as the buyer from the purchase price as, this is going to be unbelievable to you, capital gains tax we believe the seller will owe upon the sale of this business. Capital gains tax. I mean, you normally report that stuff at the end of the year on your tax return.
Right.
My seller is planning on investing his money in a opportunity zone. He doesn't intend to pay any sales tax, any capital gain tax, because he intends it to be a rollover. Okay. We are in the process of working with the state of New Jersey to respond to their questionnaire. Their questionnaire provided an exception for like-kind exchange, 1031 exchange. It did not provide an exception for opportunity zone reinvestment. Okay? I am sitting in our trust fund on almost $500,000 because the buyer didn't have a lawyer, didn't know what to do, and I said, well, you know, we were the escrow agent, and I said, as the escrow agent, we'll hold it for you, and as part of our deal, we'll hold it and deal with this. But that's a very real issue that came out of complying with bulk sales laws. Okay? We talked about selling stock. Talked a little bit about how do you structure it, what do you do? What we're seeing on stock deals is an escrow. So when I represented a buyer of these UK companies, we insisted on a sales tax analysis. We hire someone like Robert to do a calculation of what the potential sales tax burden would be, generally going back to 2015 in California and prospectively in the states that have been clear about what they're doing. We figure out what that number is. That number is then put into an escrow, held. The question is for how long? We've been saying at least 3 years. And of course, we have the problem of even at 3 years, if they never filed, potentially, it could be forever. But we agreed to 3 years. We agreed that, you know, the buyer would put a strategy together on what they are going to do about paying sales tax going forward. And this fund, the seller's proceeds, are now sitting in our trust account for 3 years. Again, for one of those cases, you know, it's over $500,000. I mean, think about this. This is money that was never collected, so this is hitting your purchase price. It is actually a ding, so you sell your company for $10 million, for $20 million. This is $500,000, $1 million, sitting in a lawyer's trust fund. The Florida bar thanks everybody because they're the ones that get the interest. But that's what's happening with the money. It's crazy. Assets. You're definitely going to have an indemnification. There is nobody who's going to take on your sales tax, income tax, or other tax liabilities arising prior to closing. If you don't disclose those issues, they're going to come back after you for fraud if it comes and hits the buyer. Okay? But at least if you disclose it, then we will say, okay, it's not fraud. You just owe the money. Okay. So on your desk, and I will thank NEXUS. I have the software that lets me do 50-state surveys. Here you go. These are the bulk sales laws. You will see some states have none. Some states put the burden on the seller. Some states put the burden on the buyer. So if you are a buyer of a company that has potentially sales tax, income tax, other kinds of tax liabilities, you might have an obligation to notify the state before you do the deal. In New Jersey, you got to notify them 10 days before you do the transaction. All right, so in our practice group, and Kevin, who's sitting out in the audience, is a member of my practice group, you know, this is becoming like a hotter topic than other kinds of, you know, normally you're worried about, are the books and records correct? Now we're worried about how we're going to deal with sales tax. Okay, then to complicate it, we now have marketplace facilitators. So what's a marketplace facilitator? I gave you a little chart. I actually updated it. We have a chart that's in the slides. I'm not going to go through it. I'm going to tell you to the one that's on your desk, because I think this is the current one I sent you the other day. Okay? 34 states now have marketplace facilitator laws. So what does that mean? It's a person that contracts with marketplace facilitators to facilitate for consideration the sale of a marketplace seller's product through physical or electronic marketplaces, such as Amazon. Okay? A marketplace seller is a seller that is not related to the marketplace facilitator or any physical or electronic marketplace operated. You could be both. Okay? You could be both. So you could be selling through a marketplace facilitator, and you could also be selling on your own website. If you trigger under the marketplace facilitator structure, like Amazon, Walmart, eBay. You're selling on those sites and you trigger, or you don't quite trigger, but then you have sites maybe direct to your own website. You add those together. This is massively confusing for smaller businesses because, as you might imagine, you now need a way to figure out when you've triggered in the marketplace, when you now trigger in your own seller system. You have to be able to add those things together. California actually has a booklet on this, on how to comply. Some of the other states do as well, but California says, I don't know what, 50, 60 pages of how you do this. Needless to say, this is a huge burden on interstate commerce. If our Congress doesn't act, this is kind of a nightmare for small business.
Not as simple as the court said it would be, is it?
No.
Yeah, not really. So what does the legislation say? Shift the sales tax collection and remittance obligations to the marketplace facilitator. They shifted it to Amazon, to Wayfair, okay? They're now responsible for calculating, collecting, remitting, and refunding sales tax. So if a product is returned, the sales tax has to be refunded as well, okay? In certain states, local taxes aren't included, meaning there's 9,600 taxing jurisdictions in the United States. There are only 50 states. So my math says 9,550 jurisdictions, some of which are and are not included in that. I don't even know what to tell you on that. So full disclosure, I'm married to a tax lawyer. So these guys, what they do, I get it, I understand it, I appreciate it. For those of us that are like corporate lawyers that do a lot of business transactional stuff, this is just like, it's mind-blowing. It's like, what the heck am I gonna do? How do I advise people when all they wanna do is be in business and be successful? So that's the chart I'm not gonna go over because that's October 11th, and since October 11th, it's changed.
Yeah.
That's why you have one on your desk. And by the way, the one on your desk might be wrong already. I printed it 2 days ago. It's going that fast.
What'd I tell you?
Okay, more than half, as we've said, so now it's 34. Amazon handles collections only for Amazon. The states will require the seller. We went through most of this. Okay, I gave you an addendum. I told you about California. So, the one thing, and I'll hand this back to Robert, but the one thing I really want to leave you with as you think about this is, as business people, somehow we have to figure out how it is we're going to keep being in business. And we commented about talking to your congressman. Really, you need to, because if we as a country don't figure out how to create a single system for this, we live in a global economy. My clients are literally all over the world. We live in a global economy, and we're either going to be competitive in the global economy or we're not. And as a country, if we don't do something about this, and if we don't get our congressmen, our senators, our judges to start to understand the burden they're putting on interstate commerce, what we're going to find is what I'm going to call untouchables. People from other countries selling into the United States because they think, catch me if you can. And the truth is, it's going to be hard to catch those guys, but they're going to be the competitive sellers. So we do have to come up with something. We really do need to address this, because the burden on all of you as sellers is huge to comply with this thing.